for me to have gone through what I've been dealing with the Department of DCFS of Los Angeles. For them to have taken advantage of me and my family the way that they have, and then expected me to fold and crumble because so many of us do, because really I am just as big as DCFS with the help of the Vincent Davis Law Firm. He helped me get my baby back. He helped me clear my name. You know what? I didn't even make it to trial. The trial that they forced. Mr. Davis showed up ready to go. They ran. They never even wanted to talk to you. They never wanted to take the stand. They never wanted to go on trial. And when I say they, I mean all of the people who were there representing DCFS. Even the council's attorney, the DCFS attorney, was trying to negotiate some things after he saw that I had such a faith in my attorney and his staff, that I had this new faith and this new solidness about myself. I wasn't scared anymore. What happened? Mr. Davis was able to not only help me get my child back, but he was able to get all of the charges dismissed. He was able to get all of the false accusations dropped. And we did it without even having to take foot on the stand.
Good morning. Good morning. This is Mastering the 388 Petition, How to Win Back Your Child When Everyone Thinks It's Too Late. Welcome to the CPS Office Hours. I'm Attorney Vince Davis, and today I'm giving you the most powerful legal strategy that exists when you are already deep into a CPS case and running out of options. This is the comeback move. The second chance, the legal Hail Mary that may actually work when you know how to use it and do it the right way. I'm talking about, in California, the Welfare and Institutions Code, Section 388 petition. And in this 30-minute live stream, I'm going to teach you what it is, when to use it, how to use it, how to win the hearing, and how to appeal if the court denies your 388 petition. So let's begin. Part 1. What is the 388 petition? Welfare and Institutions Code, Section 388. A legal request to change a prior court order based on, quote, changed circumstances, unquote, and quote, best interest of the child, unquote. It's used to reopen reunification services. It's used to increase visitation. It's used to change placement. It's used to stop or reverse the move to the termination of your parental rights. The key phrases are change of circumstances plus best interest. This is the legal way back in when the court has already started shutting you out. Part 2. When should you file a 388 petition? After reunification services have been denied or terminated. After a poor court ruling. Before the 2-6 hearing, which is the termination of your parental rights. Anytime you've made meaningful progress in the case and you want your child returned, or you want to increase or liberalize the frequency and duration or the nature of your visitation. For example, going from monitored or supervised visitation to unmonitored. A bad time to file is when too soon after the last court order, with no documented change, no evidence. I recently told someone who wanted to file the 388, I said, well, send me all of your progress reports and all of your completion certificates. Well, Mr. Davis, I don't have any. And I told them, well, it will be a waste of time to file a new 388. Go and get the evidence. Go and complete your courses, your classes, your programs, your testing. You have to have evidence to win a 388. You just can't file it. That doesn't mean anything. Part 3. Preparing a winning 388 petition. Here are some things that you must include. You must include the court order you want changed. You must include what has changed since the last hearing, and you must include why the change benefits the child. Now, you can get the beginnings of a 388 from the form itself, the JV 180. You can find this on the internet. Just search California JV 180 form, Judicial Council form. I think it's about 4 pages long, but that's just the beginning. You need some other things with it. You need supporting documents, your certificates of completion, for example, of your parenting classes, your domestic violence classes, your anger management counseling. You need letters from your therapist, your employers, your clergy, your mentors. You need your drug tests, receipts that you've been testing negative. You need proof of housing, maybe proof of employment. You need proof of sobriety, perhaps a letter from your AA or NA or CA sponsor. You need proof that you've completed that parenting class that the judge ordered. The tone of the 388 should be humble, honest, and focused on the child. Include legal points and authorities to show what the law is, to show what the facts are in your case, and to show how the facts and the law in this particular case support a change and support the change that you're asking for. Part 4. Filing the 388 petition. You file the 388 petition at the clerk's office where your case is ongoing. Before you file any 388, you must have it reviewed by your attorney. Hopefully, your attorney has helped you prepare that 388 petition. You want to make sure that you and your attorney serve all the parties in the case. For example, the CPS attorney, the minor's attorney, the other parent's attorney. You want to make sure that your attached exhibits are numbered and in order. Some courts require the JV 188 form and a written memo, the points and authorities. I would have to say some courts. I think all courts require it because I think the JV 180 is actually a mandatory form to be used in California. You know, you always want to request that evidentiary hearing. So in California, the way it usually goes is you file the 388. The judge can grant or deny you a prima facie hearing. If you're granted a prima facie hearing, you have to show up at the hearing, you and your attorney, and be prepared to argue that you deserve a full evidentiary hearing. The judge can either grant you or deny you a full evidentiary hearing. At the full evidentiary hearing, there are things that you must do. So let's talk about that. Part 5, preparing for the hearing. Treat it like trial preparation. Outline your arguments. Prepare your declarations, your exhibits, perhaps your witnesses. Line up your live or written testimony. For example, you might want to bring in your case managers, your therapists or counselors, the service providers, the visitation monitors. Dress well. I have a video on my YouTube channel about the court uniform. Show up early. Make sure you and your attorney are ready for this hearing. Sit respectfully in the court and speak clearly. Oh, and make sure you subpoena the social worker to be cross-examined if they're not in agreement with your requests. Part 6, cross-examining the CPS social worker. If the CPS social worker opposes your petition, you must challenge their claims of insufficient change, because that's the first thing they're going to argue, that there really hasn't been a change in circumstances. You have to challenge and you have to show the judge with competent, credible evidence that there has been a change in circumstances. You have to ask this worker why they didn't refer you sooner to these services if they are relying on changes that haven't occurred. You have to ask this worker for timeliness when they offered these services to you, when you completed them, and when you compiled the number of classes. The strategy, make the social worker look unreasonable while you look responsible and consistent. Part 7, appealing a denied 388. If the judge denies your 388, you want to appeal. You want to file the notice of appeal immediately. Best practice is, if the judge denies it, you and your attorney walk right over to the clerk's window, ask for a notice of appeal, fill it out, takes 10 minutes max, and file it there that day. There's a 60-day deadline in California to file a notice of appeal, and you might want to retain appellate counsel. You might be able to argue during your appeal that the judge abused his or her discretion. You might want to argue failure to hold an evidentiary hearing if the judge didn't allow you to have an evidentiary hearing. And you might be able to argue that the judge misapplied the best interest standard. Part 8, out-of-state viewers, what should you do? You should ask your attorney what is the equivalent of a California Welfare and Institutions Code 388 petition in our state. Because I would bet $1 that you have something. Because most of the states in this country model their child abuse laws after federal regulations. Most states allow post-dispositional motions to modify court orders. You just have to find the statute and what they call it. You might want to ask your attorney or search these keywords: motion to modify disposition, petition for review or reconsideration, post-disposition motions. So these are some of the things that you and your attorney might be able to search on Google. In conclusion, the 388 petition is one of the most underused and most powerful legal weapons in the juvenile dependency court system. I've used it over the years to help bring back children back home, to stop the termination of parental rights. I've used it to reopen and get further reunification services for parents, and to give parents that one last shot when they thought they were out of time. If you have questions, you can give me a call at my office. My number is there on the screen, bottom right, 888-888-6582. All right, let me look and see if there's any comments. Erica from YouTube says, I'm in Kentucky. Erica, did you have a question? All right, here's a question. Colina Maybe from Facebook. San Bernardino, California, five children, all siblings, but on two separate cases. Colina, I'm not sure that's possible. On day of court, they plan to return two, but don't want to return the 17-and-a-half-year-old, so they removed him from the case. The foster family fostering the other two is trying to keep the other two, but didn't want him, so they kicked him out. CFS is what they call CPS in San Bernardino, had nowhere to place him, so they let him come home for 10 days and then came and took him and then made him sleep in the office for 4 days with no shower rather than let him, and then it ends. You probably run out of space. Probably says let him stay there at home. Yeah, that sounds about par for the course. I'm not sure what your question was, Colina, but if they're sending kids home, they should probably send all the children home, because if they send one child home, you can't be a danger. You can't be not a danger to a child and they send them home and then claim you're a danger to the other children. I mean, that's pretty hard to do, right? Either you're a risk to all children or a danger to all children, or you're not a danger to any of the children. And if the child is 17-and-a-half-years old, I'm not sure, and they send him home for 10 days, I'm not sure why that case is even open. Okay, Tony from YouTube says, my 13-year-old son is being isolated in our local ER hospital because of suicidal behaviors, and this happened back in November, as well as I got a lawyer to come in there to help me get him out of there. Okay, well, good luck with that, Tony. Hope that works out. Colina from Facebook says they sent 2 out of 5. They sent 2 out of 5 home? That's kind of crazy, Colina. Either you're a danger to all children or you're not a danger to anyone. So how could they send 2 of the 5? Oh, here's Tony on YouTube saying, and when I went to the hospital, when he first got put in there, they were telling me that if I didn't sign papers, basically I couldn't see my son. And then they made up some lies and they violated HIPAA. Tony, that's, par for the course, my man. I hope your lawyer is working with you and fighting them. Tony says, I recorded every interaction as well, and then magically we had court after the lawyer went in there and told them they needed to release them and gave them paperwork saying he needed to be released. Okay. Tony continued. And I got the court papers 9:30 Thursday saying that I had court Friday morning and I didn't have a lawyer at the time. And then apparently appointed me one who contacted me right as I got. Okay, Tony, I'm losing the train of thought there, Tony. Sorry. We have Colina from Facebook again. My mom, the grandmom, has guardianship of 2, but not the other 3, although all 5 were taken from my mom's care. I'm the auntie. Okay. Colleen, are you wondering how to get all 5 back with the family? Tony says, I will call you. Good idea, Tony. 888-888-6582. If you call this morning, there's somebody on duty right now. They'll call and just say, hey, I talked to Mr. Davis on the show this morning, and I want to make an appointment to talk to him later on. Okay, Tony, and we can talk about your issue because it's getting a little more complex for me to try to give you some information over the comments on YouTube. All right, if there's no more questions for today, I'll see everyone tomorrow on my office hours, 6:30 a.m. Pacific Standard Time. Everyone have a great day. Bye-bye.
The only thing I've done since I've been his client is relax. And I'm telling you, that is something that for the last year and a half I have not been able to do. And I'm doing that now, and I am excited about it. He gets 5 stars and above. His assistants, the receptionists are even phenomenal. Mr. Davis, I can't thank you enough. I will never be able to thank you enough for what you've done, for listening, for just giving me your ear and your attention, for not ever approaching me as that my situation is too small for you, or you too big for my situation. You have always treated me with the utmost respect, and my family, my baby, myself, we cannot thank you enough for helping us to defeat our giant. And I will always appreciate you for that. Thank you.